from the studios at Sapere Law and Mediation, this is the Splitting Smart podcast. We're here to help you resolve divorce and family disputes out of court with practical, insightful, and real-world strategies. I'm Kelly Bennett, your host, with over 30 years in the family law, mediation, and negotiation trenches. Saving you time, money, and stress, each episode breaks down tools and tips to help you approach family law disputes with clarity, with privacy, and efficiency. Are you in a family law quagmire? Well, you're in the right place. Let's get you on the smartest, fastest path forward. The information presented in this podcast is not intended to be legal advice. It's for informational and entertainment purposes only. For legal advice, call a great lawyer. Whether you call Sapere Law or someone else, legal advice happens when the lawyer is given the opportunity to hear your specific situation and give you advice based on your unique facts. Now, let's start the show. Hey, welcome to the Splitting Smart podcast. Today, I've got back in studio with me, Sapere Pro attorney Greg Bennett and my husband. And yet we're talking about some estate planning issues. More specifically today, what happens if, like so many people, you have a family trust and then you go through a divorce? What happens to the trust and some other related issues? So we're going to get to it today. And Greg, welcome back to the studio.
Hi. Glad to be back.
We love having you here. All right. So let's talk for just a couple of minutes about, we've had a family trust and it's got all of our assets in it that we've accumulated over the life of the marriage. We've been married for 35 years and now there's a divorce going on. So once the judge says, okay, you're divorced and everything, all the assets and debts are divided, what is happening to that trust? Does it automatically go away?
Well, it doesn't automatically go away, but it needs to be at least amended or a new trust created because you divided the community property assets pursuant to your divorce judgment. So, California says that the community property has to be divided relatively equally, so the judge will divide it between the two parties. That becomes each person's separate property. But the trust calls it community property. It's still saying each party gets half of it. So you need to get a new trust or amend it, fix it, so it clarifies which of the previous community property assets are now each party's separate property assets.
Okay, so let me jump in here real quick and clarify what we're talking about. So here you've got your trust, and I like to say a trust is like a suitcase, right? And it's got a lot of stuff stuffed into it. And that would be, let's say your house has been put into the trust and you got $1 million of equity in the house. Let's say you've got your life insurance proceeds and you've got investment accounts, and those are all put into the trust. Now, you go down the road to get divorced and all those assets, even though they're in a trust, they're still considered community property assets if they were acquired during the marriage most of the time. And you might have some separate property assets in there, right? Jump in there.
Sure.
I mean, that's not uncommon.
Right. Now, people bring assets to marriages all the time.
I always like to use the example of my dad gave me an old collector jalopy car when I was 16. We didn't do anything with it. It sat in the garage for 50 years, 60 years, whatever. I'm not that old yet. And that's my separate property. I could put that in the trust and maintain it as my separate property, right?
You just state that it's your separate property and then you designate who you want it to go to, or you could just dump it in with everything else.
Right. Okay. So you've got all this property in the suitcase we call a trust. Then you go down the road to get divorced and you say, okay, judge, the community, us as a married couple own a house, the investment accounts, we own, an RV or whatever, whatever the things are.
Right.
And the judge says, okay, I'm going to award the house to the husband, the investment accounts to the wife, or something similar to that. Now, all of a sudden, what was in the box, in the suitcase called a trust that was designated as community property, you've got a judge over here saying, no, it's not community property anymore because if I give the investment accounts to the wife, They are now her separate property, her sole and separate property. And this is very similar in many, if not most of the states in the United States. And then same thing, the house is the husband's, is no longer community property. It's his sole and separate property. But you've got a trust over here that says something different. So does that automatically invalidate the trust when you have a judicial determination in family court?
Well, the code doesn't say that the trust terminates automatically.
The trust.
No, the trust, but the allocation of assets have been superseded by a subsequent court order. So the way that you state the assets in the trust have been superseded. It's no longer accurate. So you really need to amend your trust. Only one of you can keep the trust, right? So one person keeps the trust, the other person gets a whole new trust, and you change everything in it that needs to be changed to comport with the post-divorce environment. Who the trustee is, who the subsequent trustees are, the successor trustees, and what assets are now in the trust, because whatever was given to the other spouse is no longer going to be in your trust.
So what happens if both parties go and they form new trust, but do they have to formally dissolve this other one?
Yes. It's automatic in the language of the new trust and supersedes the prior trust.
I see. Okay.
Yeah.
All right. Let's talk for a minute about making sure you pay attention to this. In fact, in family law, when we do our judgments, whether you mediate your divorce or you go through the court process, you still get divorced and have everything divided. Even if there's a settlement agreement, there's still judgment forms that go with the settlement agreement. And on those judgment forms, there is a proviso that says exactly what we're talking about here. Hey, warning, go over your family trust because it may or may not still be valid.
Dissolution or legal separation may automatically cancel the rights of a spouse or domestic partner under the other spouse's or domestic partner's will, trust, retirement plan, power of attorney, pay on death bank account, transfer on death vehicle registration, survivorship rights to any property owned in joint tenancy, and any other similar property interest. It does not automatically cancel the rights of a spouse or domestic partner as beneficiary of the other spouse's or domestic partner's life insurance policy. You should review these matters as well as any credit cards, other credit accounts, insurance policies, retirement plans, and credit reports to determine whether they should be changed or whether you should take any other action.
Yeah. And that is a little beyond wills and trusts, but what it's telling us is because when we have a settlement and we're saying here's how the community estate is going to be divided, who gets what, and it's now their sole and separate property, or a judge comes in and makes the orders and puts them on you, right? In those scenarios, it's changing the nature of all these other pre-existing instruments, if you will.
Right.
And I think one thing people don't think about is health insurance. Mm-hmm. If you're on your spouse's health insurance, like through, let's say you're on your spouse's health insurance through her work, you're on as a spouse in that scenario. Right. And so if you're no longer a spouse, guess what? Right. You're no longer insured in most cases.
And you hope you don't get sick, right? You don't want to get cancer when you're in that limbo, because ultimately the health insurance company is going to figure out that you're no longer the spouse, and then you won't be able to get health insurance.
Right, exactly. Exactly. So what about a will?
Trusts don't automatically terminate, although, like we just said, the content within the trust becomes obsolete in a sense. Wills do automatically terminate. Yeah. I was trying to find you the code section. It's 6122 automatically revokes any provisions in a will that leaves property to your former spouse.
Yeah, in California. Yeah.
Or the role as the executor or trustee. So you have to replace not only who gets it. Say you have a will without a trust. You should never have a will without a trust. Okay? But if you do have a will without a trust, it automatically terminates when you get divorced.
Why should we never have a will without a trust? I mean, never?
Maybe not never. Never say never again, right? But there are certain circumstances when you have a very small estate that you can have a will without a trust.
So the bottom line is there's some limits to or maximums of the value of your estate, right? And so meaning if your estate is worth more than that threshold under your state's law,
right, then it has to go through probate, which is very time consuming and expensive.
So if you have an estate and it's worth more than that threshold maximum, and you only have a will, you don't have a trust, your heirs can't just have everything distributed. It has to go through the court, and the court has to say, yes, this is how it's going to go.
But if you did the will during the marriage or prior to the marriage, and then you get divorced, and now that will is no longer legally effective, you have to do a new will once the divorce is filed.
As to that spouse, right?
As to that spouse.
Right. So, and because typically in your will, your spouse is going to be the executor of the will, meaning they're in charge of making sure everything gets distributed, and an heir. And so that goes away.
They can no longer be an heir or an executor. It just terminates.
So let's say that you have a circumstance where maybe you want to leave something to that spouse, even though you're getting divorced. There are people who are civil about the divorce, or they've been married for a long time or something. There may be some reason.
You can put whoever you want to have as a beneficiary in your trust. So if after your divorce, you get all this, whatever is now your separate property, it used to be community property, it's now your separate property, and you want some of that to go back to your former spouse, you would either amend the existing trust or you would write a new trust, and you could include him or her as a beneficiary. Do a new trust, and that supersedes the old trust and has all the new provisos in it. And that way, especially if the trust was done many years ago, law changes, and the attorney who writes the trust will have all the updated language and whatever may have changed, like the rules with regard IRA distributions recently changed. That would have been updated in newer trusts. Which, by the way, once a divorce is finalized in California, non-probate transfers like IRAs are terminated, but life insurance policies are not. So if you have your former spouse as the beneficiary of your life insurance policy, and you don't change it, and you die, they get the life insurance.
I shouldn't laugh. It's not funny.
Obviously, you would probably want that to switch to your kids or something. And if you forget to do it, or you wait too long, and something bad happens, that could go back to the person you just divorced.
So the moral of the story here is, A, you should keep your trust updated anyway, right? Regardless. And B, when a divorce is over, it's really time to hit the estate planning attorney's office again.
Yeah, do it. Make it part of the planning and the finalization of the divorce. You just make it part of the judgment process. It's like the very next, like the next day.
The beauty of divorce mediation is we can get creative about how we come to an agreement and divide things differently than a court might divide things. But we're doing it in a way that's custom to the parties, and they really get a bigger benefit out of it. Sometimes in that creativity, someone will want to say, well, I will just make sure that you still receive this should I die, this thing. Well, the problem is if you don't handle it properly, and we always give this information, if you don't handle it properly through amending a trust or creating a new trust where it says exactly what it is you intend to do, a lot of people don't. They forget to do this. Well, if there's been a promise or it's in a marital settlement agreement, but it doesn't get taken care of after the fact and nobody enforces that before someone dies, well, you're going to be hard pressed to get that agreement honored, right?
Well, if it was in the writing, you would just have conflicting writings, and you have to go to the court to have it resolved, which is expensive. You just want to avoid it.
Right. But at the same time, what I'm saying is, if you agree to leave your soon-to-be ex, well, you can still have whatever it is, but we want to leave it in the trust so that it's protected, right? Or maybe it's a piece of your separate property. And the marital settlement agreement says he will amend his trust or do a new trust to make sure that this is specifically carved out and left. He never amends the trust, and nobody gets after him. That's what I'm getting at, is the moral of that story is, if that is some kind of an agreement, you need to make sure that it's part of the settlement agreement in the divorce case,
Right.
and you enforce it. In other words, if somebody promises to create a new instrument, leaving something to you,
Right.
and they never do that,
Right.
you need to address it with the court.
Yeah.
And
I mean, the problem with that kind of a proviso would be that the guy would never be able to sell it. He would always have to own, asset X.
I'm not saying it should be where you leave somebody something after you divorce them, but all of these issues that we're talking about and changing your trust after you divorce are so important, because the unintended consequences of these things are huge.
Right. Following through.
And, we've talked about it in other podcast episodes. We've mentioned this, but Greg, this remind us, what happens if there becomes a dispute because we didn't take care of business?
Well, you have to go to court, right? If it's a dispute over what should or should not be in a trust, it goes to probate court. Probate court is a whole new world. It's something completely different. And it's a whole new set of lawyers. It's a whole new set of rules. It's a whole new set of laws. It's a different judge. And it just turns into a big can of worms.
We've seen this on a number of cases over the years where there's a family law nuance, like a divorce. And there are some representations in court orders over here or in settlement agreements in family law. And then someone passes and there's some sort of contest in the probate court. And I've seen it where attorneys have gone in for their clients into the probate court and said, this piece of the estate needs to go to the former spouse. And the court looks at it and there's overlays like we've talked about with marital settlement agreements. And the probate court says what? Get out of here. That's a family court matter. We run over here to family court and lay out the whole scenario, and the family judge says, get out of here. That's a probate matter.
Yeah.
And that baby's no fun.
Right. Because they don't want to step on each other's toes. A lot of times, they all know each other.
They all know each other. Well, they're not in collusion.
No, I didn't mean that. I meant, if their friend wrote an order, they don't want to supersede the order if they can give it back to them to fix.
It's not like they point to each other and say, go back to the other guy. No, I don't want to deal with it. You go to the family judge. But all I'm getting at is it's time consuming. And the general rule in litigation is, and whether it's in family court, probate, or civil court, the longer a case goes, the more expensive. Yeah, do that again. The more expensive it is. Do it again.
Big bucks.
The big bucks. So, all right. Well, there should be no messing around when it comes to your estate plan and divorce. And I think, Greg, what you were saying is, look, your estate planning changes should go hand in hand with your divorce, whether you're going to court and a judge is going to decide your life for you. I really hope you don't do that. I hope you go the mediation route, or you go through mediation and you settle everything, right? As soon as that settlement or those final orders get into place, your very next step, you should plan the estate planning piece.
That's exactly why many of your family law clients are also my estate planning.
Right, exactly.
Because we strongly recommend that they make these changes, the changes as they're going through the divorce that you can make, and certainly the changes that need to be made immediately after.
Yeah.
And if you have a trust in place, all you have to do is fund it with a separate property. It's super fast and easy.
Yeah, and in the long run, it's the wise thing to do.
Right.
And I would argue it's also the loving thing to do, because the last thing you want to have happen is that lack of clarity upon your passing, because the pressure it puts on your family members having to live through all of that.
Right.
It's not what you want.
The whole point of having a trust is to make things clear and inexpensive.
And smooth.
And smooth, right.
Yeah.
And if you just forget to update your trust or whatever, you're putting that in a situation where it could cause conflict. You'd have to go to court and incur attorney's fees, and it takes a lot longer, and all these things can be easily avoided by just
100%
getting yourself a new trust or updating the existing trust, depending on what you're doing.
And nobody likes the idea of their children getting into those kinds of disputes over something that you could have clarified.
Right.
Because those are the kinds of disputes that ruin relationships permanently.
Right.
And I think that would be very much grieving to a father's or a mother's heart. Good word
Okay.
today.
My
Thanks for
pleasure.
joining me.
All right.
Would you like me to serve as your personal mediator? You know, where to help you and your spouse or your soon-to-be ex navigate some pretty important family law issues, deciding things about your kids, how to split up your assets, your debts, all outside the chaos of the court. How do we do that? We do it faster, way more economically, and with absolute civility and confidentiality. If you want to know more, go ahead and hit that link below, and you'll find out how you can connect with me, and we can talk about what's most important to you and your future.